The Milimani Law Courts, where there's the Employment and Labor Relations Court annual open day at Milimani, and Gladys Kashanja is following the activities there. Gladys, what's happening at the moment?
Thank you, Mark Masai. Yes, we are at the Milimani Law Courts, where the annual open day for the Employment and Labor Relations Court is officially open. And this is something that has been going on for a while now for the Labor and Relations Court. And remember, this is actually a devolved court. This is concurrently happening at the Nakuru Law Courts and at the Kericho Law Courts. Now, on this open day, the stakeholders, that is the members of the public, are actually given an open day to walk in and talk to the different stakeholders and get information on the different labor relations to do with employment, employment, trade organizations and what have you. And this has been going on for a while now. But to actually give us more details on the same is a principal judge at the Employment and Labor Relations Court. His name is Justice Matthews Nderi Nduma. Thank you for joining us. This has been a devolved court for a while now. How long has it been devolved?
This court was established in 2012 under the new constitutional dispensation, and it was set up pursuant to Article 162 of the Constitution and the new Employment and Labor Relations Court Act. It is devolved. It's a superior court of record for the first time, because before we had a tribunal, which was a subordinate court. So for the first time, the workers of this country, the employers of this country, matters are dealt with by a superior court of record, which is devolved currently in Mombasa, Nakuru, Kericho, Kisumu and Nyeri, and we intend eventually to devolve the court to all the counties. We are in the process of opening sub-registries, and recently we have opened sub-registries in Meru, Eldoret, Malindi, and we're in the process also of getting to Kisii, and hopefully sooner than later this court will be felt in every county of this country.
Okay, you also changed the name from the Industrial and Labor Court to the Employment and Labor Relations Court. Was there any purpose for that?
That came out of the constitutional negotiations at the Bomas, where the new court was proposed, and it was felt that matters dealt with by this court are not just in the industrial, that we deal with matters of employment to do with individuals, and we deal with collective disputes, which are mainly labor disputes, and we deal a lot with relations at the workplace, and therefore the name industrial was not appropriate, and it was felt by the stakeholders that the title Employment and Labor Relations Court is more embracing, and indeed that's why the court was named that way.
The court has gone and become devolved to the different counties. What are the results you're seeing after this happened?
The court is being felt at the workplaces all over, because as soon as a court opens in a county, the people get to know about it, and they start asking questions and become aware that there is a forum where they can take their matters which arise at the workplace, which are not resolved there. So we are seeing a lot of growth in awareness by both employers and employees on their rights and how to have those rights vindicated by the courts. And so that is the immediate impact, that there is a growth in awareness of the workers and the obligations of employers. And they know now that there is a big brother nearby who is watching, and we're getting very positive developments at the workplace in terms of respecting the rights of the employees and also to the obligations of the employers.
As you talk about Big Brother, today is an open day. Here in Nairobi, there's one going on in Nakuru and another in Kericho. What should the citizenry expect from this open day?
Today is a day to open ourselves as a court to the consumers, to give them opportunity to ask questions, to get to know better the operations of this court, and to better understand what we do on a daily basis and the procedures required for them to file cases, how complaints by the people, the consumers, may be dealt with on a day-to-day basis, and especially the issues that concern the people, the consumers of justice, is a delay in the delivery of justice system. So we are letting them understand some of the reasons why matters may not proceed as fast as they would expect, and the steps we are taking to make sure that their cases are handled faster than it has otherwise been. And we hope we'll have a very fruitful engagement with all the stakeholders today in that respect, so that they can understand the court better and they can also understand what they are required to do as the consumers of the court to get better service from us.
Okay, now the Employment and Labour Relations Court has been very busy, especially the last couple of months. We cannot ignore the industrial issue that went on for a while that had to do with the doctors. Now, as much as the citizenry was watching to see what the Labour Court would say about that issue, what are some of the lessons the Labour Court actually learned from that?
The court is an institution of last resort, especially in labor matters, because we have the Ministry of Labor, which has the institutions that handle disputes emanating from the workplace before they come to court. We have what we call the Tripartite Committee, which is under the Commissioner of Labor and the Minister of Labor. As a court, we feel that there should be more intervention by the Ministry of Labor in this matter, and by being proactive and intervening in these matters before they come to court. And that is one lesson, because 100 days for doctors to be out there and without seeing either the Minister of Labor and the Commissioner in the picture was sad for us. We also learned that as a court, I think with every case is a new lesson, and the outcome of the teacher's case, which effectively said that the court should not intervene directly and arbitrate or adjudicate or award terms and conditions of service to disputing employers and employees, sort of incapacitated the court. And that is the result of what you saw, that the court sending the parties back every time to a third party, when in actual fact the Employment and Labour Court, in terms of Section 73 of the Employment Labour Relations Act, is empowered to intervene directly and adjudicate on matters that have not been agreed in a collective bargaining agreement, and make awards, specific awards to the parties, whether be it the employer or the employees, so as to avert strikes. This is
In as far as the doctor's strike is concerned, you said 100 days was too many to have actually gotten, it shouldn't have gotten that far. But the question here is, some critics were saying there was a bit of a political inclination or influence on the Labour Court in as far as how they saw the proceedings go. Would you say the court is actually independent?
This court is very, very independent, and especially under this new dispensation from 2010. We were anchored very well by the erstwhile Chief Justice Mutunga, and there's continuity in that from our new Chief Justice Maraga. And I can say without fear of contradiction that we have tried our best to be independent, to dispense justice without fear, favor, ill will, or affection. And we do that. But what I would want to say is that letting disputes remain until the last minute and then run to court seeking for injunctions at the last minute is not a good thing, especially for government. It's good to be proactive, and I think courts should be not very ready to grant orders to parties who have not utilized the conciliation, mediation, arbitration procedures under the Ministry of Labor. I think we should be more reluctant to entertain parties who rush to court for injunctions when they have not themselves submitted themselves to the mandatory statutory procedures under the Ministry of Labor. So I think our consumers should note that we will be probably more unwilling to do that, because we've learned lessons of defiance of court orders, sometimes for good or bad reasons, although there is no excuse for defying a court order. But at times, I think we also need to be more careful as we deal with these matters, which are very emotional and involve very many number of workers.
Thank you for your time. We have been speaking to the Principal Judge at the Employment and Labour Relations Court, Justice Matthew Zinderi Nduma. As you've heard, what he had to say is that this Labour Court has been very busy in the last couple of months. One of those cases that was in and out of that court had to do with the doctor's strike. That industrial action went 100+ days, one day too many for the court, and of course for those that were actually affected by that strike. But one thing he also says is that they learned a lot from this, and one thing is that they have and they're putting it out there to players, is that you need to get your act together before you run to the court, because they feel that most people do not exhaust the channels they have of mediation and intervention before they get to the courts. Hence you get to court and clog up the system and also draw out an industrial action unnecessarily. Well, Mark Besai, as I said, it is the annual open day at the Labour, Employment and Relations Court here at the Milimani Court. It is happening concurrently at Nakuru Law Courts and also happening at the Kericho Law Courts. This is an opportunity for Kenyans to come in, find out what the court can do for them in as far as matters, employment relations, employers relations, and even trade organization relations. So all those questions will be answered here at the annual open day at the Employment and Labour Relations Court. We'll be giving you more details on the same, and of course talking to some Kenyans on their experience and what is it that they expect from the court and what are some of the hits and misses, if you will, and that will be coming to you as soon as we get them back to you in studio.